And I believe the actions of the complainant when he says he was driving down the road and stuck something out the window of his car, to which the immediate response was to my client's reacting. I can certainly see how my client could have the impression that perhaps if instructed properly and educated on the laws of self-defense, we might not be standing here today. But more importantly, I think we can tell from the conversations with my client and the previous gentleman that there was a lot going on that morning. I mean, first, if you read the reports, he passes him and slows down to take a picture. If you hear today, he drives off and then slows down so he can catch him. There's a bad driving on everybody's part, perhaps. But I do know that, my client, as he's told the court, feels terribly about what's happened. He did not intend for this to be the result of his actions. However, it is the result of his actions. He has applied for deferred adjudication. He would certainly like you to consider that application. I would bolster that consideration with the fact that he's never been in trouble for anything. Now, in the event that the court denies his application for deferred adjudication, then I would certainly ask the court, when considering the range of punishment, to look below this 25-year cap. I certainly don't think that in this case, with these facts, that number is attributable to what happened, if you will. Once again, he's never been in trouble. He was part of a incident on the roadway that both of these cars were involved in. Both of them were sticking things out of their cars. I do believe that at that time of the morning, it was still pretty dark out. I think he's an excellent candidate for deferred, but if you do not give him deferred, I ask that you consider the lower range of the punishment. He has been in jail 10 months, almost 10 months, waiting for this day. All right, that's all I have, Judge.
State.
4 inches, Judge. That is the amount of distance between this being an aggravated assault and a murder. It's 4 inches. If that shot had been higher than 4 inches, Jalen wouldn't be sitting here. He would have been left by Arnold Benia on the side of that highway to die. And even more so, Jalen wasn't even armed. They searched the vehicle. This man shot an unarmed 17-year-old in the face and has the gall to ask, give me deferred so I can walk right on out that door. Even more so, he says that he's justified, but he doesn't do anything to show that he was in the right. He covered this up. He never told anyone. He never told 911, and the gun was cleaned off. And he said he didn't do anything with the firearm, and he put it away a day afterwards. That is impossible without some kind of tampering by Arnold Benia. And further, Judge, I want to go to page 13 and 14 of Sean O'Neill's report. This is in stipulated evidence, and it goes into admissions that the defendant made on his jail calls. And I quote, referring to Jalen, he put himself in danger. At the end of the day, I did what I did, right? And I took off first. They got me with this shit because they took ballistics on my gun when they took it. And that's the only reason why they pretty much know what happened. The callous disregard of he put himself in danger. They wouldn't have caught me if they had done all of this. The only reason I'm in here is because of ballistics. That is not a person that is apologizing and taking responsibility. That is a person who is upset he got caught. I know that Mr. Benia is talking about his 17-year-old, now 18-year-old stepdaughter. Jalen, 17, 18-year-old is 18-year-old as well. And he's going to have to deal with what Mr. Benia did for holding up a phone for the rest of his life. So, Judge, I am absolutely vehement that deferred is well below what should justice be done here. 5, 10, 15, 20 years is well below what justice requires here. Justice requires that the cap all the way 25 years with a finding of deadly weapon be applied in this case. And that is what I'm going to ask you to do, Judge, to sentence him to the cap, the maximum 25 years with a finding of deadly weapon.
Right. And do parties agree that the amount of restitution is $4,987.42? That's what's in the PSI report.
I agree that's what's in the PSI. I can't state for the veracity of that number, but that's what's in the PSI report.
All right.
4987.42.
And Judge,
So, yes.
I would have to discuss that with Lisa and Jalen about if that's the proper amount. Because I can't, with 6 surgeries, it has to be higher than that.
Okay. Norma?
Yes, sir.
Recall this. He's going to recall this in 30 days with regards to the restitution. Is that enough for everybody?
Yes, Judge.
Absolutely.
All right. What date?
Okay. So May 20th? Oh, no. You said
Sorry.
You want to do the June 8th?
Yes, please.
June 5th.
All right. So we'll address the issues of restitution on June 8th. This is what I want you to realize. One, I read everything. I keep an open mind about everything. And I look at the facts, basically what's in the stipulation, and I consider all the testimony that is given to me. And I understand that you have 0 criminal history, right? So I take all of that in consideration, all the evidence that's presented to me. Okay. So this is what the court is going to do. The court is going to find you guilty, give you credit for any time served. There's a $2,000 fine, time and money to run concurrently. There's to be restitution hearing on June 8, 2026. There's an affirmative finding of deadly weapon, and the court will sentence you to 15 years. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
I would like to address that.
Yes.
Yes, at the time he signed it, he had no rights to appeal, but having had the motion to withdraw the plea, I have, and I'm going to tender to the court a notice of appeal specifically on that issue. So
Right. And could you do me a favor? Could you, because the trial court certification, I think, was originally
one.
Yes.
I would prefer that if you don't mind.
Yes, because that was originally signed by Judge Angelini because he took the plea.
Okay.
All right. All right. So the trial court certification of defendant's rights to appeal, you do have a right to appeal. That's related to any type of pretrial motions that were heard and that were ruled upon. And you did have pretrial motions in this case that were heard and ruled upon by me. The motion to withdraw your plea being one of them. You understand?
Yes, ma'am.
Okay. Now, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question about what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
Okay. And so we'll be back on June 8th to determine restitution amount. Your attorney will be given information on what the state is proposing restitution be. And if y'all can't reach an agreement on that, I'll make a decision. Okay.
Okay.
All right. Thank you.
Thank you.
And Judge, at this time, I'd like to tender to the court if I could. First, the notice of appeal on my client's behalf. And then secondly, my motion to withdraw solely so the court can appoint him an appellate attorney to handle.
All right. So,
But I'll stay on for the purposes of the restitution hearing. I don't want to delay his appellate rights. Since he's been sentenced today, the clock starts. So maybe you can make my notice effective June the 8th or something.
okay. And can I have the trial court
Oh, I'm
certification?
sorry.
That's okay. What's that? And Norma?
Yes, sir.
Oh, there's no order. But Norma, appointed appellate attorney, and see if that appellate attorney can be here on June 8th, whoever it may be, so that you'll have a chance to speak with them at that time.
Thank you.
And then your motion to withdraw,
Just hold
we'll
on.
deal with it
Okay.
after that. Yes.
That's fine. Thank you.
There's victim impact.
We done? All right.
There's a victim impact statement.
Oh, they have a victim impact statement.
Okay.
So on your case, Zavala, he didn't make transport. All right, recall May 4th.
I was gonna recall it potentially just for Monday, only because I have another client in here on Monday.
All right.
Is that May 4th? I'm sorry.
Yes,
It
May
feels like a
Today's
long time away. and-
She needs to sign it.
Okay. All right. See you then.
Sounds good, Judge. Judge, also, family violence wanted to bring something up.
May we approach,
Yeah.
since he's still here on an off docket matter?
Yes.
Case of Mr. De Leon's client, Martha Frias, was set on the jury trial docket on May the 12th. We have a motion for continuance, Your Honor. We would like to argue, that, we have an essential witness who is unavailable that week at our St. Mary's, Ms. Shannon Murphy, who is on an approved vacation for that week. She is an essential necessary witness as she has completed the defendant's SANE exam. And she is essential in that she's needed to establish the first link in the chain of custody for any DNA evidence that will be entered into.
And is there DNA evidence?
Yes.
Yeah, there is.
Okay.
Judge, I can tell you the court that I have a murder trial on 437 set the same day, specially set, so I'm not jumping in up and down opposed to the state's motion.
All right. Well, is your client is on bond, right?
Yes.
All right. So if you want to have him by Zoom on Monday, because he has to be here for me to rule on it.
Okay.
And then I'll take care of it.
Judge.
All right. Thank you.
Thank you, Judge.
You're welcome.
Good, may I approach?
Yes.
Jalen has so long to talk to you.
Ready? Judge, there's a plea up there. Williams, Angela Williams.
Angela Williams.
Ready.
I'm looking forward to you. And we need to.
Reveles. Reveles, did you turn into? I just need to approach for a continue.
Court is calling 2026 CR 000269 State versus Angela Williams. Can I have parties announced for the record for the state?
Lauren Esposito for the state.
Roger Bettis for Miss Williams, Your Honor.
And are you Miss Williams?
That is correct, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Miss Williams, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
I believe, Judge, we are proceeding on the lesser included offense of attempted
It's a
injury.
class A misdemeanor.
No, I think you all are just proceeding on assault bodily injury.
Oh, yes, Judge, we are proceeding on assault bodily injury. Apologies.
No problem. And I understand you're probably not the one who worked out the plea.
No, Judge.
So I only know because I'm reading the admonishments. Any objection?
No objections, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor, but could I ask you a question?
Sure.
What you just said to abolish, assault to bodily injury? What do that mean?
Do you want to talk to your client about that?
Yes, Your Honor.
In this segment, the defense argues for leniency, claiming the incident arose from a chaotic roadside encounter where both parties contributed to unsafe behavior, emphasizing the defendant's remorse, lack of criminal history, and request for deferred adjudication or a reduced sentence. The prosecution strongly counters, stressing the severity of the crime. An unarmed 17-year-old was shot in the face, and argues that the defendant showed no true accountability, attempted to conceal evidence, and only regrets being caught. They urge the maximum 25-year sentence. After considering all evidence, the judge sentences the defendant to 15 years in prison, imposes a fine, and makes a deadly weapon finding, while scheduling a later hearing to finalize restitution. The defendant is informed of limited appeal rights, and an appellate attorney is to be appointed. The court then proceeds to other matters, including scheduling issues and a new case where a defendant confirms understanding of charges related to assault causing bodily injury.